Good afternoon, everyone. Welcome to today's bite-sized session on CE and UKCA marking. I'm Amy Swindles, Head of International Professional Services at the Chamber, and I'm also joined by our partners, Squire Patton Boggs, and we've got Nicola Smith, Director from there, who's going to lead most of today's presentation. We will take questions at the end, so if you have any questions, if you can post them in the Q&A box throughout the session, and then we'll have some time at the end to go through those questions. I'm just going to give a brief introduction for those of you who don't know the Chamber, to ourselves and what we do, the support we offer, and then we're going to hand over to Nicola. So the Great Manchester Chamber is a membership organisation offering business support. We have 4,200 members. And we are one of the largest accredited chambers of commerce in the UK. We offer a range of international trade support. We've obviously been very busy this year post-Brexit, and we've been running these bite-sized sessions fortnightly, hopefully covering some topics that are of interest and are impacting your business at the minute. And we've also launched a chamber customs service to help with the import and export documentation process. We have lots of support on offer for market entry, so helping you look for customers, distributors, agents overseas, across the world in all sectors. We offer a host of training courses to help with the import and export process, and also compliance services if people are needing things like export licenses or have customs audits coming up and they want somebody from our team to come out and look at the processes in place, and that support's also available from ourselves. We offer a range of export documentation and import documentation, as well as the customs clearance and the transit and T1 documents. So anything like certificates of origin, EUR1s, ATA carnets, temporary export document, come to ourselves and we can give you advice and help to produce those documents. And then we have a range of getting paid services, so insurance, if you're having problems with FX and currency fluctuations, again, speak to one of the team and we can hopefully put you in touch with one of our partners. These are our upcoming events. So as you can see, we have these bite-sized sessions taking place fortnightly. The next one will be on the immigration system, and then we're going to have one at the end of October on ATA carnets. And in there you can see we've got a range of training courses on things like rules of origin, international supply chains, and also customs declarations. Just before I hand over to Nicola, we just asked we've got a few brief questions we asked you to help us with answering today. So we're just going to launch the first of our polls, which is how would you describe your company's export experience? You can just see those results coming in. Just going to give it a few minutes. And I'm just going to share those results now with you, and so Nicola can see as well. So most of the people on today's call are experienced exporters, so 63% experienced exporters, and we've got a few occasional exporters in there. Just going to reshare the slides. And I'm going to hand over to you, Nicola.
Thanks very much, Amy. Good afternoon, everyone. Thanks for dialing in today. As Amy said, my name is Nicola Smith. I'm a regulatory lawyer at Squire Patton Boggs Solicitors. I specialise particularly in regulations which affect all sorts of products made of all types of materials, ranging from things such as consumer products, food and drink, food contact materials, but also machinery and products which are subject to requirements for conformity assessment, like machinery, electronic equipment, and electrical products subject to electromagnetic compatibility requirements. And as such, I advise businesses on what they need to do to comply with product safety and labelling requirements, authorisations that they may need to sell certain products, and also on dealing with enforcement agencies in the event that something goes wrong, or at least is alleged to have gone wrong. And I've been seeing a number of queries in recent weeks and months from businesses who are supplying or buying machinery and other products which are subject to EU product laws, particularly those around conformity assessment and conformity marking, where those queries relate to the impact of Brexit and the new UKCA mark. But also connected with that, connected with the labelling in any event, impacts on things like name and address labelling requirements, and associated issues with customers and suppliers in the EU, which businesses in Great Britain have been facing in taking their products across the border. So if you can move on the slide, please, Amy. So today's session should probably be about 30 to 40 minutes for the slides, and then there will be time at the end for questions. As Amy said, you can use the Q&A function for that. But in the main session, I'm going to cover the conformity marking and the changes that have resulted from Brexit, in particular moving from CE mark to UKCA mark. I'll also touch on UKNI markings, which are relevant to the Northern Ireland market. I'm also going to cover the requirements for UK declarations of conformity. As I say, we're going to look at the name and address labelling implications, which are not directly associated with conformity marking, but are is another common question that we're getting, and the impact on that of the fact that economic operator status has changed as a result of Brexit. And then finally, we're going to touch on how enforcement of these regimes work across the EU. If you can move on the slide again, please. Thank you. To start with, though, I'm going to turn to the impact of Brexit on those conformity assessment markings. And I'm sure you will all be familiar with the CE mark on the right of the screen, but by way of reminder, it's a mark which has been used in the EU and the UK for a number of years for many different types of products. And I'm sure that most of you will be aware that that CE marking is a key indicator of a product's compliance with EU legislation. And what it essentially indicates is that the product is declared by the EU manufacturer, the importer into the EU, or indeed a notified body in some circumstances, that the product is in conformity with harmonised EU legislation. And most new products have to be marked with this mark in the EU, including things like machinery to indicate compliance with the Machinery Directive, electrical equipment to indicate compliance with Low Voltage Directive and electromagnetic compatibility regulations, but also consumer products like toys, aerosols, medical devices, certain construction products. As I said, there are many new products that are required to have this marking. It's not the equivalent of a kite mark. It's not intended to serve commercial purposes as a marketing tool to demonstrate quality, which can be a common misconception. What it is, as I say, is an indicator of compliance with legal requirements. So that is what the mark is intended to signify. And actually the mark itself is the result of a whole process of conformity assessment. So checking that the product complies with the requirements of those EU laws, and that the technical standards for those products that may be within those EU laws. And it often involves checking compliance with a particular harmonised standard. In terms of the conformity assessment process itself, that varies depending on the type of product. For many products, there will be a declaration of conformity by a process of self-assessment. So declaring that the product conforms because you've reviewed the standards and ensured that as a manufacturer or a representative of the manufacturer that product complies. But generally, for some products that need higher and stricter safety standards, then you might need something called a notified body to be involved. There are lots of notified bodies around, companies like BSI or TUV or SGS, where the notified body has to actually assess the product or the design and manufacturing standards to confirm that it conforms with the requirements. Once you've got this mark on the product, i.e. the CE mark, that enables the product to move freely in the EU, regardless of where it's manufactured. And that's because countries in the EU aren't permitted to restrict products which are CE marked from being placed on the EU market unless there's evidence that the product doesn't actually comply with the requirements. So in short, that CE mark means that there's a presumption that a product complies with the requirements rather than a presumption that it doesn't. But let's move to the mark on the left, and that is the mark that following Brexit will be required for sales of products in Great Britain. So essentially in Great Britain, products will move from the CE mark to the UKCA mark. And the reason that I've spent a few minutes talking about and refreshing people's memories on what the CE mark means and what it signifies is because very similar principles are going to apply to the UKCA mark. So that UKCA mark is essentially confirming the conformity of the product with relevant regulations. The difference is that the UKCA mark will confirm conformity with UK regulations rather than with EU regulations. But again, the process of that conformity assessment it is, at least at the moment, very, very similar. So again, in most cases, it will be a self-declaration that a product conforms, or for those sort of higher standard or perhaps more risky products, the involvement of a notified body. And the UKCA mark, much like the CE mark in the EU, is going to allow access to the UK market, and there will be a presumption of conformity once it's applied that the product complies with UK standards. If we can just move on to the next, oh, you're already on the next slide, okay. So moving on to UKCA markings, as it says on the slide, it's going to, the UKCA marking affects all products which are placed on the market in Great Britain since the end of the Brexit transition period, so from the 1st of January this year. And it will affect all products which previously had to be CE marked. So if your product was in the scope of CE marking regime, it will almost certainly also be in the scope of the UKCA marking regime. The mark itself stands for UK Conformity Assessment, and as I say, it's essentially confirming conformity with UK standards. Although it's worth saying, I think, that certainly as at the 1st of January this year, UK standards and the conformity assessment procedure is pretty much identical to that for the EU and the CE mark, because part of the exit process from the EU was that all EU laws carried over automatically into domestic legislation. So as I say, at the moment they're identical. There is also some indication that the standards and the requirements are not likely to change in the UK anytime soon. because UK guidance has been issued which says that there aren't any plans to diverge at this time. Although that said, we will have to watch this space on that, because I am aware that there was a speech last week to the House of Lords by Lord Frost, saying that all retained EU legislation is going to be critically reviewed, so that anything that is not suitable for the UK can actually be removed. So as I say that with a note of caution, because it may be that we do have some divergence in the medium to longer term. There is a transitional period. It was the case that the UKCA mark was going to be required after the 31st of December this year. But the red line shows the change that was made at the end of August, which essentially pushed that date back by a year. So it's now anything that comes onto the market in Great Britain after the end of next year. So after 31st of December 2022, or from the 1st of January 2023, depending on how you want to put it, is going to need to have a UKCA mark. If we can move to the next slide, please. There are a few exceptions to that sort of general position. The first is in relation to Northern Ireland. Northern Ireland, because of the effect of the Northern Ireland Protocol, is pretty much treated as being a part of the EU. So products which are placed on the market in Northern Ireland will have to have the CE mark. That is with one exception. That exception being where products which are sold in Northern Ireland have to have assessment by a notified body, and the notified body that is carrying out that assessment is based in the UK. And if that is the case, then you have to use the UK NI mark alongside the CE mark, because the UK notified bodies cannot, well, they're now called approved bodies, but they cannot certify to EU standards for the standard CE mark, and therefore, as I say, in those circumstances, products in Northern Ireland may have a UK NI mark, but the UK NI mark would not be sufficient to sell in the rest of the EU. The other sort of slight change to the general position is where a product needed the involvement of a third party notified body, and that assessment was done by a UK assessment body. For very similar reasons, that would mean that your product would have to have the UKCA mark from the end of the Brexit transition period, i.e. because the UK notified bodies aren't permitted to certify to EU standards following the end following Brexit, and therefore if your product needs third-party assessment, and that assessment was done by a UK notified body, then it should already have the UKCA mark on rather than the CE mark. And then the final sort of exception to the general position, which is on that slide, is if there is a divergence of standards. We've as I've mentioned, it may be that happens once retained legislation is reviewed, and if there is a divergence of standards, such as the product meets one and not the other, obviously you would not be able to continue to use the CE mark if the product no longer meets the EU requirements. So if we can just move on to the next slide, please. I think there is. I think it's worth saying that there are some further transitional period provisions in addition to the grace period, which allows you to continue to use the CE mark up until the end of next year, and that is that there is an extra year from the 1st of January 2023 to the 1st of January 2024, where it is likely that you will be able to put that UKCA mark on an accompanying document or on a label rather than on the product itself. Because the guidance when the transitional periods were changed says that legislation is going to be introduced to allow that extra year. The other thing that is worth mentioning in relation to that is that although from the 1st of January 2024, the UKCA mark in most cases will need to be affixed to the product itself, except where that's not possible, for example, because of the sort of exceptions that apply now for CE marking on the product itself. For example, if you've got a very small product, it's worth remembering that there are some products where those grace periods don't apply, as is detailed on the slide. And then finally on this slide, I've flagged placing on the market because it's very possible that goods could continue to be sold in Great Britain without the UKCA marking past the relevant dates, because it's arguable that a product is placed on the market in Great Britain legally before it's actually physically transferred and imported into Great Britain. And that's because according to guidance that has been issued for fully manufactured goods are placed on the market when there is a written or verbal agreement or an offer of an agreement to transfer ownership or possession or another property right in the product. And that does not require the physical transfer of the good. So hopefully you can see from that guidance that there is this, as I say, this possibility that you could still have products sitting in stock in Germany, for example, which you could argue have already been placed on the market in Great Britain because you have entered into an agreement to buy those specific products from Germany prior to the relevant dates, even though they haven't actually been shipped yet. And in terms of how you could provide evidence or proof of that, then the guidance says that you could look to documents ordinarily used in business transactions. So that might be things like contracts of sale for goods already manufactured. It might be invoices. It might be documents concerning the shipping of goods for distribution. So purchase orders, for example, could all help to demonstrate that a good has been placed on the market in Great Britain before it's actually shipped into Great Britain. The relevant economic operator will actually that's wanting to establish that it was placed on the market already is going to bear the burden of proof for demonstrating that. Documents proving the sale of those goods before the relevant date should obviously be retained carefully where that you might need to rely on that type of argument. But in summary, bringing all of that together, for most products up until the end of next year, you don't have to have the UKCA mark on the product usually, but you can do if you want to. And then for the extra year, so between the 1st of January 2023 and the 1st of January 2024, it's likely that the UKCA mark, although mandatory, can go on a label or accompanying document. And after that, so from the 1st of January 2024, you will treat the UKCA mark in Great Britain like you would have done the CE mark for the EU. So it must be affixed to the product in most cases. But that will vary depending on the specific regulations that apply to the particular product. If you're manufacturing the product, it's normally you that's going to be affixing the UKCA mark, but other parties in the chain, sort of importers and distributors will still have responsibilities to check under the legislation that the right conformity assessment mark is on there. Can we move to the next slide, please? So the Declaration of Conformity, I just wanted to touch on this because as I've explained, the conformity assessment mark, whether it be the CE mark or the UKCA mark, is linked to the whole conformity assessment process. And the requirement for a UK Declaration of Conformity is one that for many that in my experience, many businesses aren't actually aware of. But the UK Declaration of Conformity is a document which must be drawn up for most products which are lawfully bearing that UKCA marking. In the document, you as the manufacturer or your authorised representative, where that's allowed for in the relevant legislation, would have to declare that the product's in conformity with the relevant statutory requirements applicable to the specific product. And it will include various details such as the name and address of the manufacturer or the authorised representative, the information about the product itself, and if a notified body or approved body in the case of the UK is involved in the conformity assessment, their details as well. And that declaration has to be available to market surveillance authorities if they request it. So the information on the Declaration of Conformity is going to be largely what was needed on an EU Declaration of Conformity. They are going to look very, very similar, but obviously the heading will be different because it will be a UK Declaration of Conformity rather than an EU one. And importantly, the legislation that you quote may be different. So whereas with the an EU Declaration of Conformity, you might be referring to the Machinery Directive, i.e. the EU legislation. Within the UK, and on the UK Declaration of Conformity, you would be referring to the Supply of Machinery Safety Regulations 2008. Because you're declaring compliance with UK laws rather than EU laws. That will, of course, be slightly complicated by the fact that where requirements are governed by a regulation in the EU rather than a directive, those regulations have come into EU law at the end of Brexit because they've been grandfathered over, as I say, automatically. So you may still have the EU law on your Declaration of Conformity for the UK in those circumstances, because the retained law will have the same title, and it will just say at the end, in brackets, retained law. But as I say, it's just important to make that distinction because that is going to be the document that is available to enforcement authorities. And then finally on this slide, I just thought it was worth noting that in addition to the UKCA mark itself and the UK Declaration of Conformity, the manufacturer and the importer are going to have certain responsibilities connected with these conformity assessment and declaration processes. As we'll come on to in a moment, you might have the same supply chain as you've always had, but if you are importing something into the UK from the EU, previously under the legislation, you would not have been considered as an importer, because within the EU, an importer is defined as someone that imports a product into the EU, and therefore somebody when the UK was part of the EU, as I say, you wouldn't have been an importer under the legislation. But now you would be, because the way that EU regulations have come over into UK law mean that importer is now defined as an importer into the UK, and therefore you will be legally defined as an importer in those circumstances, and you will have the responsibilities that an importer has. So looking at conformity assessment, for example, you'd normally find that the manufacturer has got responsibilities for carrying out the conformity assessment, setting up the technical file, issuing the declaration of conformity, and placing the conformity marking on the product. But the importer and distributor also has responsibilities to check the presence of that marking, to check for necessary supporting documentation, and in the case of an importer, checking that the manufacturer has complied with the certification requirements for the marking. As I say, it's just worth remembering that you may be bearing additional responsibilities. And equally, if you're exporting from UK to EU, the same is true the other way, because your customers who would never previously have been considered an importer under EU legislation, because goods were going from EU to EU, now they will be considered an importer under the legislation and will therefore have the same responsibilities. So if you're exporting rather than importing, you may very well find that your customers are wanting more details from you as to the processes that you're carrying out for your declarations of conformity and your sort of conformity assessment process. Especially because there's a new regulation come in to force in the EU called the Market Surveillance Regulation, which makes even clearer that if the manufacturer or their authorised representative isn't based in the EU, then it will be the importer that bears the relevant responsibilities for compliance with EU law. So as I say, that is leading to additional demands from EU customers. If we can move on to the next slide, please. I think the top point I've just covered in terms of the changing operator status and the sort of the same persons in the supply chain for the same products now having additional responsibilities. But the last point on there is related to that, but it's specifically connected with name and address labelling rather than conformity marking. And that is because most product regulations require the product to be labelled with the manufacturer and the importer details. Previously, of course, something going EU to EU that was manufactured in the EU would not have had an importer on, because there was not considered to be any importer in those situations, because it's going EU member state to EU member state. And therefore, if you are bringing something in to the UK that was manufactured in another European country, so Germany, for example, it's no longer enough just to have the German manufacturer name and address on there. You are going to have the UK importer address on there. Similarly, the same applies the other way round, because if you're manufacturing a good in the UK that is now going to the EU, because of these requirements for importer addresses to be on the label, your customers, as we said a few minutes ago, are now going to be becoming an importer under the legal definition, and therefore they're going to be obliged to make sure that there is an importer name and address on the product label. So they will be looking at those labels as customers with a much greater sort of scrutiny and focus than they have done previously. And I've found that many of my clients have actually been getting questions that are completely unconnected with Brexit and the results of the impact, if you like, of the UK's exit from the EU around things that haven't changed at all. So language requirements, for example, for instructions for use. I've found clients are having customers in the EU questioning that, and the rules haven't changed, the leaflets haven't changed in relation to languages, but because of this greater scrutiny of language, of information and labels, customers are picking up things that they never have done previously. We can perhaps move to the next slide, please. And this is the last slide that I wanted to cover, but essentially it's around the way that product laws are enforced across the EU, and even where product laws are governed by EU regulations, which means they're directly applicable in all EU member states, the enforcement of those laws is under national legislation. And therefore the enforcement that you see of labelling and marking requirements, both in terms of penalties, but also in terms of the approach of enforcement authorities, can vary significantly from France to Germany to the Netherlands, for example. So if you have a query or concern, or there's a particular grey area that you are not sure about, or where you have a particularly big market, it may very well be worth getting local advice in those countries as to how local legislation affects the sort of overall obligation and how local enforcement authorities are looking at these types of issues. I think it is worth saying, though, that as I said earlier, there's a new regulation in the EU called the Market Surveillance Regulation, and as well as sort of specifying that the different parties within the EU have got responsibilities, there is also an introduction of a product compliance network database of enforcement data. And we understand that that database is going to contain information on things like product testing, enforcement actions, information on shared initiatives by different member states, authorities, etc. And we're going to have to see how that plays out in practice, but it is expected that they may result in a more coordinated approach. In the UK, enforcement is generally proportionate and risk-based. There's a code of practice for regulators which talks about the importance of proportionate and risk-based enforcement. So that means that, you know, where something is a genuine error that's not causing a safety concern, it's more likely to result in a warning and consultation with enforcement authorities in the first instance, rather than straight to prosecution, for example, in most cases. But I think it's probably likely that as rules become more embedded and transition periods expire, and certainly if we do see some divergence between the EU and the UK requirements, we may well see more enforcement over coming years. And if we just move on to the next slide, that's just my contact details, which will come around if you've got any specific questions that we don't have time to address today. And that brings us to the end of the slide part of this session. So have we got any questions that have come in? I I hope that's been helpful. I'll wait a minute and see if we have.
Thank you, Nicola. I think that was really useful, really in-depth presentation. Thank you for joining us. If I can just ask if you post any questions in the Q&A, while we're perhaps waiting for people to type in questions, could I just ask you to complete a couple of short polls? I'm just going to launch one now, just about how you're currently dealing with your customs documentation in the EU, and then a quick one as well about how you're finding the movement of goods since the 1st of January this year. Thank you very much. And like I said, if you've got any questions, if you want to post them in the chat and the Q&A box, and Nicola will be here to answer them for a few more minutes. Perfect. And just share those results. So most people are either doing your documentation yourself or using a customs agent. And the last poll, just about how you're finding the movement of goods since the 1st of January. The chat box seems very quiet. You must have answered everyone's questions, Nicola. And Nicola, I know we've had a few people contacting us at the Chamber because finding the gov.uk website quite general. Is there anywhere you would recommend that they can go for further guidance, or is that currently the best resource? Obviously they can contact yourself, but any other good online resources people can use with lists of products that would perhaps need the UKCA marking?
I think for the UK probably is the best resource, Amy. It doesn't always answer all the questions. There's still quite a lot of grey areas, but I think it's probably the most complete information, and it's what the regulators will be looking at. I think if you're exporting to the EU, it's helpful to look at some of the guidance from the EU. So there's a website, I think it's europa.eu, which includes guidance from the European Commission. And there are a number of sort of Brexit notes produced by the European Commission, and they can be really worth looking at if you've got a particular product type, because that's the source of information that many enforcement authorities in the EU are going to go to. But certainly for the UK market, I think gov.uk is probably the best place to start.
Perfect, thank you. We have had a question in the chat box. I'm not sure if you can see it. It's about languages required to be present on product labels. I'm not sure if that's specific, or you can answer that now.
Yeah, I can. This is always specified by the particular regulation for the product itself. And for most of the harmonised regimes in the EU, which have come over to UK law, it says that the EU level regulation will say that it has to be in a language that's easily understood by the countries where the product's going to be placed on the market, or by people in the countries where the product's going to be placed on the market. And the local legislation in each member state that implements the sort of general overarching rule will say what those languages have to be. So you will find, for example, that in countries like Switzerland, there will be a number of languages that you can use. For others, it has to, as a minimum, be in one particular language. So in England, for example, it's, well, in the UK, it has to be English. In Ireland, it has to at least appear on there in English. In France, it has to be in French, etc. So it depends where your product is going, and it depends what the local legislation says as to what language it has to be in. But typically, it's going to be in the common languages of those countries. So what many producers will do if their products are going to many countries is that they will look at sort of the most common languages in the EU and ensure that they translate for all of those languages to minimise the risk of any challenge. I think we've got some questions as well, haven't we? Will our suppliers in the EU have to have the UKCA? Okay, yeah, this is a really good question. So if your suppliers in the EU are sending their products into the UK, yes, they should be UKCA marking it as well as CE marking it. Because if they're placing it on the market in the UK, it has to have the UKCA mark, and you as importer have to be responsible for checking that it's got the UKCA mark. Now, the reason that it's a good question is because in my experience from speaking to other clients, lots of suppliers in the EU are not willing to UKCA mark or don't understand what a UKCA mark is. So I don't think it's something that's commonly understood at the moment, but certainly those products will have to have a UKCA mark on after the end of the relevant transitional periods. And then we've got another question about medical devices. Do medical devices have to have the local language? Yes, they do. That was already a requirement under the medical devices legislation. But again, it would be the legislation of the particular country you're sending it to that would specify what that language has to be. And then we've got another one. If you subcontract your manufacturing, who is responsible for creation of the technical file? Usually the manufacturer is the only party that has all of the necessary information for completion of a technical file. Well, it depends on, so the answer to that is it depends who the manufacturer is in terms of the legal definition of manufacturer, because the legal definition of manufacturer in most of the relevant product regimes is not necessarily the same thing as the person that actually makes the product. If you are having the product designed or manufactured to your order and you're selling it under your own brand name, you will be considered as the manufacturer, even if the actual production is done by a third party to your specifications. So it's the legal manufacturer that has to create the technical file, not necessarily the actual physical manufacturer. And then I think last question, do they need to have labels in local language as well as manual, please? Again, it depends on the regulation governing the product, but most product regulations that require instructions for use or safety information do require that they be in a language easily understood by the consumers of the country where the product is marketed. So yes, that would apply to sort of the manual, if you like, with that safety information or instructions for use in, as well as to the label.
Perfect. Thanks, Nicola. I think that is. I think we've just got one last question. We'll just take one last question and then we'll wrap up the session.
Is the subcontracted company legally obliged to supply the legal manufacturer with the information necessary to complete the technical file? I mean, I think the answer to that is not under the legislation. The legislation places the obligation on the legal manufacturer. In practice, though, it would be governed by contract ordinarily. So the contract between the legal manufacturer and the person that they're subcontracting with would require the subcontracting company to supply the information necessary. I guess the other thing that you could say about that is that the subcontractor, although not specifically obliged by the product regulations to supply that information, would itself have general sort of health and safety obligations and responsibilities. And if they didn't provide accurate or correct information, it's likely that they could face liability under those sort of general safety obligations, but what those general safety obligations would be would vary from country to country. So that is something where you would need local law advice. In the UK, for example, it would be something like the Health and Safety at Work Act, which requires that you have due regard to the safety of your employees and other persons, but every country will have a slightly different version of that.
Thanks, Nicola. I think that's it. So what I'm going to do is I'm just going to launch a final poll just on feedback for today's session. We will follow up with the slides and the recording of the session, which we'll put on our YouTube channel and on our Brexit Hub. And any other questions, please feel free to contact